So I always do that. But because I don't want, I'm trying to remove it. So that we can move to the...
It's good to know that you're moving on.
Yep, there we go. That's good. Okay, so I am going to specifically speak, and if you can't hear me, you can just raise your voice. I mean your hand. I thought there's a mic, but it's okay. So I am going to specifically speak about, reflect on the jurisprudence of the Zimbabwean Constitutional Court since 2013. But why is it appropriate to do so today? It's because the Constitutional Court was established as a permanent court on 22 May 2013, when the 2013 Constitution of Zimbabwe was adopted. So 22 May marks the first 6 years of the existence of that court as a permanent court, and today is 23 May. Coincidentally, the month of May is also the Africa Month here at UCT. So there is no better day than today to actually look back and reflect on the jurisprudence of this court. Specifically, my intention is to make an assessment as to whether the Constitutional Court, when you look at its jurisprudence since 2013, you can characterize it as a constitutional court in practice or as an anti-constitutional court. I know it's called constitutional court on paper, but is it in practice, is it a pro-constitution court, or it's actually an anti-constitution court? So my desire this evening, what are my intentions? So my intention this evening is to draw conclusions which will not necessarily excite you, or which you will agree with me on. But well, if you end up agreeing with me, I'll be glad. But what I really seek to do is to share with you some views which will provoke you to reflect critically on the notion of judicial independence, the relationship between law and politics, and what the judgments of the constitutional courts in Zimbabwe are telling us about the relationship between this court and the executive. Although my presentation is primarily on the Zimbabwean Constitutional Court, the observations which I make are quite relevant to many other African countries. In fact, what I attempt to do this evening is, especially for my non-Zimbabwean audience, is to suggest a theoretical approach or template for evaluating and analyzing the jurisprudence of similar courts in your own jurisdictions. So everyone is covered, right? Everyone has got a piece in this case. So what is the scope of my presentation? So the point of departure for my presentation is that judicial independence is the notion that courts must apply the law without undue interference from both the state and non-state actors. However, and this is, I think, one of the most important parts of my presentation. However, this evening, I'm confining myself to examining whether the Constitutional Court of Zimbabwe has demonstrated its independence from executive control, at least since 2013. And there are various reasons why I focus on executive control. We can discuss them in the plenary if you are interested. In my analysis, I will look at the manner in which the court has adjudicated in politically sensitive cases. What do I mean by politically sensitive cases? These are cases which involve high-stake political consequences, but which implicate questions of constitutional law. It is in such cases where the executive is likely to interfere with the court, because the court's decision in those cases are invariably likely to have a massive impact on the governing parties hold onto and exercise of governmental power. So that's really why I chose to focus on what I characterize as politically sensitive cases. So the constitutional framework on judicial independence in Zimbabwe, on paper, the Constitution of Zimbabwe guarantees the independence of the judiciary by, number one, stating in section 164 that the the judiciary or the courts shall be independent of direction, control, and influence of anyone. And secondly, it guarantees security of tenure and benefits for judges. And thirdly, it sets out procedures for fair and transparent judicial appointments. Notwithstanding these constitutional guarantees, the Constitutional Court has come under fire as it is accused of being controlled by the executive, especially when deciding in politically sensitive matters. So the question whether or not, in my view, the court is in practice independent from executive control can only be determined by examining its decisions. However, what must be avoided this evening is adopting a purely legalistic approach where the analysis of the court's judgment is limited to the substantive law and reasoning of the judges. I argue, as many other scholars have done, that law is a social phenomenon and therefore constitutional provisions and judicial appointments do not exist in a vacuum. The interpretation of constitutional provisions often generates more than one possible meaning, and a particular meaning is preferred in a particular case because of the facts of the case as well as the social conditions within which the law operates. And we must first understand these conditions, what these conditions are, in order to appreciate why the court decides in the way that it decides in specific cases. So in this sense, I find Jeremy Bentham's theory of complete law, which some of you may be aware of, as a useful conceptual framework for analyzing the Constitutional Court's jurisprudence since 2013. The theory of complete law was developed as part of the classical positivist legal theory. And the question that was on Bentham's mind when he developed this theory is, what is law? For him, law comprises of two things. Number one, the legal provision on paper. Number two, more importantly, the system or institutions responsible for the interpretation and implementation of the law. So he argued that in order for us to know what the law is in a particular case, we should not narrowly focus on what the legal provision says, but rather we should focus on, open quote, factors by and through which a legal provision is made operative, close quote. So put differently, the meaning of law is the product of an interpretive process in which certain factors beyond the legal text are considered. So in Zimbabwe, the judiciary has the formal mandate of interpreting the law. However, the question is, what are the operative factors which influence the way the court has interpreted the law since 2013? I've put this provision on the screen. And it's a provision that a lot of you will be familiar with because it exists in many constitutions. It says the fundamental rights and freedoms set out in this chapter may be limited only in terms of the law of general application, and to the extent that the limitation is fair, reasonable, necessary, and justifiable in a democratic state, blah, blah, blah. So stripped to its essentials, that provision, and I think it applies across jurisdictions. This rule dictates that for a limitation to qualify as lawful, it must be reasonable and justifiable in a democratic state. Yet, as the Supreme Court of Zimbabwe has on its own accord admitted, this is not a straightforward, clear-cut assessment. It is not. So this is what the Supreme Court in Zimbabwe said, so that you don't think it's my own claim, because there are judges here, right? So this is what some of the judges in the Supreme Court, which was the apex court before 2013, said. Oh, no, it's not. But why? Can I have some help here? Because I wanted to go to this slide, right? what is basically happening is it's not reflecting what I'm.
That's one way of dealing with it.
The slide that I want to show you. Yeah, go to Smith. The slide that I want to show you is this one. Right. The slide that I want to show you is where the judges of the Supreme Court in Zimbabwe. Yes.
No.
He wasn't a judge.
I'm pretty sure.
Okay, so that's the one. That's the one. Yeah.
Okay.
So this is what the judges in the Supreme Court, the apex court, said. What is reasonably justifiable in a democratic state is an elusive concept. One which cannot be precisely defined by the courts. So the students of law are expecting the courts to define it, but the courts are saying this cannot be precisely defined by the courts. There is no legal yardstick, save that the quality of reasonableness of the provision under challenge is to be judged according to whether it arbitrarily or excessively invades the enjoyment of a constitutionally guaranteed right. What I am trying to say is that the court enjoys discretion in most cases when determining whether a limitation is reasonable or not. It therefore can never be denied anymore that there is usually more than one interpretation to a constitutional provision, and judges exercise discretion and make choices when interpreting the law. And their choices become the operative interpretation of the law. So what can't be denied is, I think we have always known that there are more than one possible interpretations to the law. But what cannot be, what I think is for a long time been a subject of contestation, not just in Zimbabwe, but across jurisdictions, is that judges don't make choices for some reason. Judges do make choices. And whatever that they choose becomes what the law says, right? We therefore have to discuss this question in view of the fact that judges make choices. We have to discuss this question this evening. And the question is, what is it that informs the choices which judges, particularly of the Constitutional Court of Zimbabwe, make when interpreting the law, especially in politically sensitive cases? I know what some are probably thinking, especially if you are just coming from completing an LLB. You will probably argue that the judges only take into account, number one, the facts, number two, the legal provision, number three, the relevant constitutional values. Is it, I can't remember, but there are books that have been written on this, right? Yes. Legal provision, you know the principles of statutory interpretation. This is what they tell us, that they take into account the facts of the matter, the legal provision, its grammatical construction, and then the relevant constitutional values. And then they apply that, and then they arrive at a decision. And in the process, if they are to make choices, they are guided by those. This view is inspired by a combination of the social contract theory and Ronald Dworkin's rights thesis, which I'm sure you are familiar with. But just to highlight that the social contractants perceive law as some form of a social contract amongst the people. And then Dworkin suggests that when faced with the legal question, the court must resolve it by strictly applying legal principles. And in so doing, they must be guided by the values of liberty, equal concern, and respect for everyone, which underpin the social contract. And that view is captured in section 46(1)(b) of the Constitution of Zimbabwe, and so in South Africa, and so in Kenya, where they say, when interpreting the fundamental rights and other provisions of law, you must do so in a manner which promotes these constitutional values. However, resorting to constitutional values does not necessarily resolve the uncertainty in the law, because constitutional values do not have a singular meaning. For instance, the meaning of the value of human dignity and liberty is a subject of contestation amongst judges and scholars. Ultimately, the court's preferred meaning of those values depends on the social context within which the law was enacted and operates. So we still come back to social context. Right. Thus, the claim that judges consider the law only when adjudicating complex cases is a myth. They go beyond the legal text to consider operative social context and conditions. The question is, what are these social factors? What are these factors which they consider? I'm trying to canvass and demonstrate why we must exercise our minds on this particular question. And why this question is not just relevant to Zimbabwe, but it's relevant across the board. But of course, when we are going through LLB, sometimes we are not told these things. Well, we are told, but then it's not adequately discussed. In the Zimbabwean context, this question can be investigated using Peter von Dupe and Rachel Elliot's systemic level factors theory, in which they argue that there are factors within the political system which determine whether the court rules in favor of or against the executive in a politically sensitive case. And these factors include the political risk which a certain judgment would pose to the ruling party, right? But my view is, if you consider political risk as the only factor, then it would mean that every time a politically sensitive case was coming to the Constitutional Court in Zimbabwe, the executive was losing, right? I mean, was winning. But that's not the case. There are 5 cases where the executive actually lost. So in my view, Elliott and von Dupe's theory is inadequate to that extent. I argue that we must retain what Elliott and von Dupe have suggested, that political risk is part of the calculation which the court does. But there are other factors which they certainly consider. In Zimbabwe, as I will demonstrate in a few minutes, internal political dynamics within the ruling party have dictated or appear to have dictated the direction which the Constitutional Court has taken in specific cases. So that's number 1. Number 2, the changes in the regime's political strategy regarding how it intends to retain power often determines or requires the court to rule against the executive in certain cases, as you will see. So I want to show you something which I agree with von Dupe and Elliott, that when a court is confronted with a case that is politically sensitive, which poses a serious risk to the regime, the court will rule in favor of the executive. I want to show you what happened in one case. The case is called Jelas Mawari versus Robert Mugabe. This is the first case that was decided by the Constitutional Court when it was established in the new constitutional era. So the background behind this case was that in the previous election, because you should get this for you to be able to understand why it became a politically sensitive case. So the background behind this case was that in the previous elections held in 2008, ZANU-PF had lost the ruling party. ZANU-PF had lost parliamentary majority to the opposition. The presidential election had produced an inconclusive outcome, and this led to a SADC, Southern Africa Development Community, facilitated political settlement which saw ZANU-PF sharing power with the opposition in a government of national unity. One of the key objectives for the government of national unity, as dictated by SADC, was to institute electoral reforms in order to ensure that the elections to follow in 2030 would be free, fair, and credible. Right. But then what happened is that ZANU-PF stalled reforms for almost 4 years. So they blocked the reforms for almost 4 years using the power that they had, both in parliament and in the president. Then when parliament was just about to be dissolved on the 29th of June 2013, some people then said, no, we now want elections. And the elections must be held now. But here is the problem. The problem is they could not proceed to organize elections without SADC's support. Yeah? Because SADC had just made it very clear that they would not support any decision. And President Hama from Botswana was very vocal on that particular issue, Ian Hama, that there will not be elections in Zimbabwe until electoral reforms have been put in place to make sure that it's a free, fair, and credible contest. So what then happened is, and I don't want to speculate, I'm speaking carefully here. What then happened is a citizen approached the Constitutional Court with an application saying, citing the president of the president of the country, the then president of the country, Robert Mugabe, as the first respondent, and asking the court to order him to set an election date, and that election date must be by the 1st of July, which is a day after the parliament would have dissolved. Some have argued that this must have been President Mugabe's strategy of using the court to set an election date so that he can then say to SADC, I also wanted elections after reforms, but the courts, they've just told me that I must have elections immediately. Your guess is as good as mine. What then happened is that the matter came before the courts, and the court made a ruling to the effect that elections must be conducted immediately. I want to show you something. In that case, because we should not just criticize courts, we must go to and look at what the law says. In that particular case, this is the provision which governs the dates for elections. It says a general election and elections for members of the governing bodies of local authorities shall be held on such day or days within a period not exceeding 4 months after the dissolution of parliament. This is the grammatical interpretation of the law. And I'm not making it up because even the court agrees with me. It agrees in that judgment that yes, that is the grammatical interpretation of the law. But we reject it as judges. Why? Because we are going to fashion a purposive interpretation of that because they say a purposive interpretation of this provision would produce a result which tells you that by the time that elections must be held immediately, at least a day after parliament is dissolved. Huh? Why? Because they say the framers of the constitution could never have contemplated that we could go for 4 months without parliament. And for that, using that approach, they reached a conclusion and handed a judgment which led to Zimbabwe having an immediate election, which is what President Mugabe wanted. We then had an election without reforms, and you know who won those elections. Right. So that is one case where, in my view, there was a political risk. If the court had followed what the grammatical meaning of the law says, it was going to hand down a judgment which would say elections are due on 30 October instead of 31 July. And that would pose a risk to ZANU-PF of losing the elections because ZANU-PF would benefit more if elections were to be held immediately. I'm not going to discuss about the other case. It's there in the paper that I'm going to publish. It's Mavedzenge versus Minister of Justice, a case decided in 2017. It's my case. You can guess. But I want to show you, which is the second last part of my presentation. I want to show you how internal power dynamics have sort of been a factor in the Constitutional Court's reasoning and decision making. So my argument here is autocratic regimes are hardly monolithic, as they comprise within themselves of powerful rival factions that are constantly competing for power. While the leader and the ideological inclination of the regime may not be changed, the internal balance of power keeps changing, resulting in different factions exercising control over the levers of power at different episodes. This is true of ZANU-PF, the regime in Zimbabwe. Since the party took control of the state in 1980, it did not change its leader until 2017. However, the party comprised of factions which were constantly wrestling for power and to succeed the party leader. And given that the party is conflated with the state and that courts lack independence from the regime, the internal factional battles impact on state administration, including the operations of the judicial. And the case that I will refer you to is an expert application on Prosecutor General's powers, a case decided in 2017, early in 2017, before the coup that was not a coup. So the background to this expert application is that a Mr. Mavedzenge had been accused of sexually abusing a minor. However, the Prosecutor General, who is the equivalent of your Director of National Director of Public Prosecution, declined to prosecute Mr. Kereke. He also declined to issue this certificate whose name I cannot pronounce, the Nole Process. It's basically a certificate for one to conduct private prosecution. So the victim applied for the certificate and the Prosecutor General refused. The victim approached the High Court requesting the court to order the Prosecutor General to issue the certificate of private prosecution. The High Court agreed with the victim and ordered the Prosecutor General to grant the certificate. The Prosecutor General refused to comply with the High Court order and instead lodged this expert application before the Constitutional Court, in which he asked the Constitutional Court to determine whether, in view of the Constitution, he could be compelled to issue a certificate of private prosecution. He interpreted his powers, his independence, as absolute, that he is independent and therefore cannot be ordered by anyone to issue that certificate. So that is what the Constitution says. Subject to this Constitution, the Prosecutor General is independent, is not subject to the direction or control of anyone. The court interpreted this provision to imply that the independence of the Prosecutor General is not absolute. Rather, it is qualified in the sense that the Prosecutor General must independently make prosecutorial decisions, but those decisions are subject to judicial review. So some may argue that this is obvious. What did you justice want the court to say? Because it is obvious. I mean, you can't have a Prosecutor General who is not accountable to courts. But wait a minute. I say it was a straightforward case, just as Jealous Mawarire was a straightforward case. But in Jealous Mawarire, the court fashioned what it called a purposive interpretation, basically departing from what the law says. But here, the court did not depart from what the law says. In fact, there is no way in the Constitution where it says the Prosecutor General's independence is not absolute. It doesn't say that. It just says he's independent. But the court appears on paper to have been progressive, to say, the independence is relative. It's not absolute. This case was fraught with serious political sensitivities, as I am going to show you in a minute. Although the Prosecutor General is formally not a member of the executive, the ruling party has always made sure that the person who occupies that office is someone they can control, for two reasons. One, to make sure that they use that office to persecute political dissenters. And secondly, for making sure that they block any attempts to hold them criminally responsible as politicians. So it's a very strategic office for them. At the time that this case was decided by the Constitutional Court, ZANU-PF was embroiled in massive factional battles. On one side was a faction called, which I'm calling Grace Mugabe faction, because it was led by the president, then President's wife, Grace Mugabe. And the other faction is the Mnangagwa faction, which was led by the then Deputy President, now President, Emmerson Mnangagwa. This is not speculation. This is something that that played out, and in 2017 you saw how it played out. So it is not speculation that there were two factions wrestling for power at that time. Now, what had happened is the Mnangagwa faction had seemingly been able to gain control over the Prosecutor General's office, particularly control over the then Prosecutor General, Mr. Johannes Toma, and was relying on him, or rather using him, to prosecute leaders from the other faction. So it had become necessary for this man to go. It had become necessary to get rid of the then Prosecutor General, Johannes Toma. And the court became so frank, unusually frank. If you read the judgment, I have never read a worse criticism of a senior government official by the court as I read in that judgment. What then happened is that the court said the Prosecutor General can be compelled by a court of law to issue a certificate for private prosecution. So they ordered him to comply with the High Court order. And subsequently, Mr. Mnyarazi Kereke, whom he was protecting, and who seemed to belong to the Mnangagwa faction, was eventually tried, convicted, and is serving his sentence. But what happened to the Prosecutor General? Immediately after that judgment, an impeachment process was started, and the Prosecutor General was dismissed from office, and a new one was appointed, who appeared to be favorable to the Grace Mugabe faction, which was at that particular point much more in control of government's executive than the other faction. So what you can see there is a case where the court made a ruling which would excite all of us, and which would probably make all of us think that finally we have an independent court. But that judgment was not for us. That judgment was not necessarily because the court is independent. It was because the court is serving appears to be serving a factional agenda. And the decision that the court is handing down is one which aligns with the balance of power in the regime. So for those of you who are not from Zimbabwe, you can potentially begin to reflect on what is happening in the ANC, and potentially reflect on what is happening in Chama Cha Mapinduzi, in SWAPO, in Namibia, and see if the internal power dynamics in the ruling party or in the ruling class have any bearing on how the court decides. The last part of my presentation is where I love this particular one, because it concerns a friend. So this particular one is about how change of political strategy by the regime might necessitate that the court should rule against the executive. And again, that does not mean the court is independent or wants to be independent or is now progressive. No, it's a change of strategy, where the regime is giving away something, but without necessarily losing the machinery which it relies on to repress political dissenters. Now, State versus Monzora, a case decided in 2016. So the background to this case is that a senior opposition politician, Mr. Douglas Monzora, had been charged for insulting the president and undermining the authority of the president. So in Zimbabwe, we have this law that says you cannot insult the president. But let me show you how the law is crafted. That is how the law is crafted. Any person who publicly, unlawfully, and intentionally makes any statement about or concerning the president or any acting president with the knowledge or realization that there is a real risk or possibility that the statement is false or that it may engender feelings of hostility or cause hatred shall be guilty of undermining the authority of the president and shall serve a sentence not exceeding level 6 or imprisonment for both, and you will be imprisoned for a year, for a period not exceeding a year. So I'm going to constantly refer to this as the insult law, right? It's a law against insulting the president. Right. There's a translation there. So, Mr. Monzora, who was at that time and still remains the Secretary General of the biggest opposition movement in Zimbabwe, had addressed the political rally. And that's what he said. President Robert Mugabe chikwambo, uye achamhanya. Ndaona Mugabe achigeza, tauro muchiuno, sipo muhapa, uye nzebvu wapepe. Pamberi neMDC, pasine chihurumende chempava chinosunga vanhu vasina mhosva chichitora zvinhu zvavo. Literally meaning, President Robert Mugabe is a goblin, and he will run. I saw Mugabe bathing, towel on waist, soap under his armpits, and big head. Forward with MDC, down with bad government of thieves, which arrest innocent people and taking away their property. I want you to forget about everything and focus on President Mugabe is a goblin. Now, I want to take a little bit of a second because it won't make sense if I don't explain this, especially for the non-Zimbabwean audience. There is nothing as ridiculous as being called a goblin. A goblin, so the social context, the cultural context, the goblins are associated with witchcraft, but also there are things which don't think. So if you are called a goblin, it means you are literally someone who has no brain.
Like a zombie.
You are a zombie, but you are worse than a zombie. Because you also do evil things. A goblin is, okay, let me just say, a goblin is basically an instrument that is used by a witch to conduct witchcraft.
Like a white hawk.
Right. So a goblin doesn't decide on its own. So it doesn't decide on its own. It does things as per instruction by the witch, but also it does evil things. Because you can be a puppet and sometimes do nice things. But a goblin is something that does evil things. So that's the cultural context. And this is what my friend Douglas Monzora said, right? At a political rally. It was the state's case that by referring to the president as a goblin, Mr. Monzora had uttered a false statement with the knowledge that there is a real risk that the statement was false and that it would engender feelings of hostility towards the president. And for that reason, Mr. Monzora was facing criminal trial in the magistrate's court. Not in the Constitutional Court, but in the magistrate's court. As was expected, Mr. Monzora then challenged the constitutionality of that law. He challenged it. He said, Mr. Monzora did not deny that he called the then President Mugabe a goblin. But he said, I have said it, but that law is unconstitutional. That was his pleading. So when he challenged it, by procedure, the matter was then referred. Not the matter, that question was then referred to the Constitutional Court to say, Constitutional Court, can you pronounce yourself on the constitutionality of Section 33 of the Criminal Law Code? That is the question that came before the Constitutional Court. And this is at a time when President Mugabe was in power. But also, this is at a time when I should just read this part for you. This is also at a time when the president Mugabe had come under massive public scrutiny because he was very advanced in age. He was physically looking frail, often forgetful, falling down while he's walking, and was clearly failing to cope with the demands of his office as he frequently fell asleep in public meetings. That's what a gobbling does. But this is what he's doing. But at the same time, he is seemingly doing very evil things on the country. On the country. This is the context. So what then was happening during that time? His government was relying on this law a lot to deter people from criticizing the president, because this is 2017. This is 2016. In 2 years' time, the same party was going to go for elections, and they were saying our candidate is President Mugabe. So there was need to manage levels of criticism and protect the old men from public scrutiny. Now, this is the interesting part. When this matter came before the Constitutional Court, remember I said the question was, is this constitutional? Especially in light of the fact that the Constitution unequivocally says everyone has a right to freedom of expression. The Constitutional Court decided, in a very strange way, that it was not going to answer that question. The Constitutional Court said, we will only answer that question if indeed Mr. Monzora is guilty of having contravened that provision. Then we were all saying, oh, well, that's fine, the result is the same. Then until the court said, so this, in fact, the court, let me just say this, the court led by Malaba, then Deputy Chief Justice, now Chief Justice, basically found that Mr. Monzora had not contravened that provision, and this was his reasoning. A patently false statement to the effect that the president is a goblin was unlikely to deceive any right-thinking person into believing that it is true. It was unlikely to engender in the hearer feelings of hostility towards the president. Such a statement cannot hold up the president to ridicule. But, ladies and gentlemen, if the president is called a goblin, does that not ridicule the president? Let's not even worry about whether it whips emotions against the president, because probably at that time a lot of people were already hostile towards him anyway. But does that ridicule the president or not? It does, right? It is a violation of what? Of that particular provision. But the court said, no. He is not guilty. This is the Constitutional Court, not Magistrates Court. Constitutional Court. He is not guilty. And then they said, because we have found Mr. Monzora not guilty, therefore there is no need to determine whether that provision is constitutional or not. So, if you are not critical enough if you are doing your analysis of court judgments on the basis of what the court judgment says and what the judge says, you are likely to think that the Constitutional Court in this particular instance was progressive. Why? Because it freed, an opposition leader from frivolous persecution. But what the court did there is to give us the freedom of Mr. Monzora, but at the same time retain the law for future use. When you read the paper that I'll later on publish, you will see that I provide figures in terms of between that judgment and now, how many people have been arrested on the basis of that law. Right. Now, in conclusion, the Constitutional Court of Zimbabwe appears to have lacked independence in the past 6 years, especially to decide against the executive in politically sensitive cases where the legal position of the executive is not supported by the law. In those cases where the court has decided against the executive, it was not necessarily because of any independence to do so. but it appears to be because of either a shift in the internal balance of power between the rival factions within ZANU-PF, or it was because the regime was changing its strategy by deciding to give up certain things, but without losing its machinery for oppressive political dissent. And these conclusions, I don't make them on the basis of the 3 cases that I have presented to you. No. I make these conclusions on the basis of 11 cases. But I mean, if we were going to do this on each case, then we would sleep here, right? So I just took samples. But I'm happy to share the paper with you when it is finally published, for you to be able to have a complete picture of how many cases where the court did the same thing. So in this connection, impeachment of constitutional imagination, whose realization will only come true when the right political conditions exist. Thank you.
I'm not sure whether I enjoy listening to justices research more or listening to the joy that justice takes in his research. It's always a great pleasure to hear him. I would like to take maybe 2 or 3 hands if we have 2 or 3 hands. If not, we can go and eat snacks immediately. Oh, okay. 1, 2, 3. Go.
Thank you.
Do you say who the question is?
Yeah, so my question is directed to Chris and sorry, I didn't take. Yes. So in the South African context, I mean, when you started your presentation, you said something about, well, the judges are not elected officials, you know, the counter-majoritarian rule. But in the South African context, how far true is that statement? I mean, we know the way the JSC works. You have 23 commissioners, and by the end of the day, they actually, don't they vote, I think? They vote, isn't it? And those 23 JSC officials, basically they represent your sectors of society. You know, you have your political parties who are represented. So, in my view, isn't that, I mean, electing really judges? They come there and, yeah, they present and, you know.
So, you're going to think about that for a bit?
I can give an answer straight away if you prefer, but I can wait for the
Well, let
others.
me take 1 or 2.
Thank you. My question to Justice. From your presentation, you seem to allege that the courts in Zimbabwe are captured. So my question is, in the meantime, what can ordinary citizens do to attain justice against the state going forward? Up until to the time we've got the proper political climate.
Yeah. Okay, my question is for justice as well. I'll begin by making a comment. So if you compare how the courts have related with politics in Zim, that is before 2018, around 2002, when we had the Gabay court, the government used to interfere directly with the judges by, for example, withdrawing bodyguards from their homes when they are deciding politically sensitive cases. But later on, they realized, no, this is not such a smart move, so they decided to staff the courts with their own judges. But then we have observed that with the new judges which were staffed by the ZANU-PF regime, there has been a tendency to collude, as she said, capture, right? So my question as well was is how then do we hold the judiciary accountable, since they use the law to actually further the interest of the regime in a subtle way?
Sure. Nives, you had a question, but if you could keep it short, and then we'll go to answers, and then we'll do another round there.
Thanks. I think that, isn't it that the terminology of the judiciary ruling against the executive has some blind spots and shortcomings? Isn't it supposed to be like the judiciary is supposed to rule to uphold the constitution, the law, and human rights? Because at the end of the day, isn't it that the judgments are not supposed to produce a zero-sum game where, you know, this one is against and this one is antagonized, but it's supposed to say we are promoting the values. And in the case of, that is just one in terms of that. And then in the case of what we're saying, Justice, particularly the example that of the gobble, yes, which I can't say it now. The issue, isn't it like, I mean, what would you say in the case of South Africa, where we had the Democratic Alliance SMS case, where they said Zuma must pay back the money, he's a thief and all that, and then there was a judgment upholding the freedom of speech there, particularly because it was in the context of an election campaign. So as you were reading it there, it's like forward with ZANU, with MDC, and it shows exactly that it is in a context of an election campaign where the debate and the freedom of expression is supposed to be more robust as compared to what it would be outside of that. Yeah, thank you.
Thank you. Can I come to you guys first on the question of the election? Is it really an election?
Yeah,
Isn't
so
it just an election?
Well, I mean, we could sit here and talk about the JSC and how it makes its decisions all night. I mean, God knows, thanks for that question. I think it does point to difficulties with the counter-majoritarian narrative, and I think you're right to point out that that is not as simple as it appears. I think I'm using it, I suppose I'm using it here to take on critics of supposed judicial overreach on their own terms. And I think although, yes, there is an extent to which there is a link back to political accountability, I suppose I would contrast it to the situation that some US states have, for example, where judges are properly elected on a ballot box. I sat through a very interesting presentation many years ago during my LLM in the States of people talking about that, and it's an extremely bad system that we should avoid at all costs. So I think there are good reasons for it. I tend to think it's not as big a concern for judicial review as it often gets portrayed. But I think we also, and this again comes back to the point Matt was making right back at the beginning about our bubbles and our perspectives. And perspective as a lawyer is to say, no, but that's, you know, that's what the courts do, that's their role. But we also, we do have to acknowledge that there is, I think, a difference between the link to direct democratic accountability between how we appoint our judges to how politicians are appointed. But of course there are many layers of nuance. I mean, the executive is not directly elected either. So I think a lot of the separation of powers rhetoric does break down under closer consideration. And basically I just wanted to pick up your point there on that framing of ruling against the executive, and I think you're right that it's more nuanced. But at the same time, that is how the executive itself often frames the issue when it's having a go at the judiciary for supposedly overreaching. You're ruling against us too often, and so when the executive and ruling parties are framing it in that way, then we tend to be having the debate in those terms, and I think that's part of what goes on there.
So quite a few questions for you.
Yeah,
I wanted to add one,
okay.
which is, what's wrong with the good old Marxist, good old-fashioned analysis, which is that courts serve elites. They are an elite and they serve elites, and they're there to maintain the systems of power and patronage that have been set up by the way society is structured.
Okay. The beauty about Zimbabwe, and which is why I think we should constantly discuss about Zimbabwe, is it's a theater. All this, whether it's economics, it's in Zimbabwe where you know, all rules and principles of economy or economics were rendered useless. Political theory is also. So I enjoyed studying Zimbabwe. It's a theater. If it was Manchester United, it would be a
Theatre of dreams.
nightmares. Manchester United is in shambles. Okay, so I think the first question is from Kudzai about, so how do we seek justice, right? So I'm going to give you an academic answer and a practical answer. But the academic answer is that it depends on what you call justice and depends on which theoretical framework you're operating from. If you are a social contractant and you believe in the social contract theory, which says that the Constitution is a contract between people, and when we are aggrieved, we must go to court, and then the court will make a ruling between me and the state or between me and society. That theory is irrelevant in Zimbabwe. What is relevant in Zimbabwe at the moment is, I think, which is why I spoke about Jeremy Bentham, because I think his theory is more relevant. Before he developed the complete law theory, he had also said, which is the part that I left, he had also said, the law is a sovereign command, which means the law is what the sovereign, which is the ruler, says it is. Of course, that probably would be scary to say in South Africa, or maybe in Kenya. I don't know what Doug thinks. But in Zimbabwe, I'm not scared, because I think that's the reality, that the law is what the sovereign or the ruler says it is, because of the political conditions. So what that means is, you then, if you have a conflict with the ruler, you go to the ruler for justice. It doesn't work. So what I'm trying to say is, then, to the practical aspect of it, what I'm trying to say is, I think when we look at Zimbabwe and access to justice, bringing politically sensitive cases to court is a hopeless enterprise, because that case will never be determined.